Welcome, everyone. I get the topic that none of you needs to know about until you suddenly do. Pre-litigation panel hearings. What are they and why do they matter? Hopefully by the end of this lecture, you'll understand that it's been in the back of your mind and it can probably just stay there. I have no financial disclosures to make. But let's talk a little bit about this. And if you have questions at any time, please feel free to interrupt. Trial attorneys are used to judges interrupting them at any and all times. So the Utah Healthcare Malpractice Act is what governs the pre-litigation panel hearing process. It's found in Title 78B, Chapter 3, Part 4 of the Utah Code. If anyone needs a good alternative to a sedative, go right there. It is very, very boring. But the pre-litigation panels have been around for a long, long time, almost 40 years in Utah. They were adopted in 1985. Today, they're handled through DOPL, which schedules those panels when they're needed. What is a pre-litigation panel hearing? Basically, any claim that is made against a healthcare provider has to go through a pre-litigation panel review before litigation can commence. And who is a healthcare provider? Under the state law, anyone and everyone. The general rule is if you have to ask if you're a healthcare provider, you are one. It includes audiologists, dental hygienists, birthing centers, midwives, hospices, social workers, marriage and family therapists, counselors, licensed athletic trainers, doctors, nurses, hospitals and clinic, and anyone similar. So those are all specifically called out in the statute, but anyone who might be argued to be similar to those is also a provider. Here's the statutory definition. Any person, partnership, association, corporation, or other facility or institution who causes to be rendered or who renders healthcare or related professional services. If you're under DOPL, you're going to be under this particular provision. One thing to know. If someone has a claim, they have to bring it before it reaches its expiration date. To make a claim and get to a panel, a patient cannot wait forever. It's 2 years from the discovery of the injury, no more than 4 years from the date of the act, omission, neglect, or occurrence, and 1 year from the discovery of a foreign object in the body, 1 year from the discovery of fraudulent concealment of a claim, or from when the injured party should have discovered the claim. How is it started? Well, a patient has to file 2 documents with DOPL. One is called a notice of intent to commence action, and the other is a request for pre-litigation panel review. That request is just, get me on calendar. It's a form, has no real information. The one that we care about is the notice of intent. They're filed with the division and they're served on the healthcare professional. They set forth the basic facts of the claim and a request for relief. If the provider is a government entity, say it's someone it's the University of Utah Hospital, then this notice of intent alone is not enough to start the process. They also have to comply with the Governmental Immunity Act and provide those required notices as well. Okay, I've received a notice. Now what? One major takeaway, report it immediately to your health insurance carrier. They will provide counsel for you to represent you through the process. They will basically assign you an attorney who can get you through this process smoothly and help you focus on your practice while the attorney's focusing on dealing with the pre-litigation panel. Once you've received a notice, you have to file your own notice of appearance with DOPL within 10 days. This is usually done by insurance counsel. You have the option of filing an answer before the pre-litigation panel, but it's not a foregone conclusion that that's a good idea. If you've got a complicated treatment history, it may be helpful to let the panel know some of those details right out of the gate. But otherwise, if it's fairly straightforward, you're just educating the other side by filing the answer. It's not required. And you can explain everything in the panel hearing without having filed that answer. How to prepare for a panel hearing. All right, once you've got your appearance filed and you're getting ready for that, under the statute, they've got to set the panel hearing within 180 days, unless everyone agrees in writing otherwise. What's happening during that time? DOPL's going to reach out to everyone and make sure that they can agree on a date to come into a conference room and hold that panel hearing. You'll receive a list of the panelists so that you can object that persons have the wrong specialties. If you're an MD and they've got someone else, if you're a DO and they've got an MD on the panel, you may want to say, hey, there's enough difference in what I was doing here that I want to have a DO on the panel. There are different classifications of midwife. If you're a direct entry midwife and they have a certified nurse midwife, you may object that they've got the wrong person to be assessing your standard of care. Also, if you have a prior supervisor who's shown some bias against you in the past, you'll want to object to having that person on the panel. During this time, you're creating a timeline of the treatment of the patient. You'll be sending subpoenas to DOPL, and DOPL will issue those subpoenas to medical providers. When a case is in pre-litigation, DOPL has the authority to issue subpoenas on both sides' behalf. It's not formally in court. There's no court process for subpoena. So you cannot get a patient's education or work records that you would normally be able to get during litigation. You can just get their medical records. And that's really important because it helps you get the narrative put together at a very early stage. You'll know all of the treatment that they've received from other providers, all the things they didn't tell you at a very early stage. This is probably the number one benefit to healthcare professionals, is the chance to get to know the full treatment history across healthcare systems, across state lines, for this patient at a very early stage. It's also a chance for you to reach out to other members of your profession and to line up an expert who can testify on your behalf that you have, in fact, complied with the standard of care. Sometimes your area of practice may be very specialized, and there isn't anyone in the state that is willing and able to testify on your behalf. And that this gives you time to look to Colorado, to Montana, other states that are within easy traveling distance that may have an expert in your specialty. Does the panel hearing even matter? Here's the truth. The pre-litigation panel does not make or break any case. It is informal. It is non-binding. It is confidential and closed to the public. It's inadmissible and closed to discovery in subsequent litigation. Dentists, I don't know who their lobbyists are, but they are immune from pre-litigation panels. They're governed by the rest of the Healthcare Malpractice Act, but dentists do not have to go through pre-litigation panels. There's a special exception written in for them in the law, though their practices may have to go before the panel. If all parties agree, you can waive the pre-litigation panel hearing. And the parties may have a mandatory arbitration agreement, and nobody's going to litigation. They're going to go to arbitration, and that kind of renders all of this moot. So if it doesn't bind and it doesn't ultimately decide the issue, then why do it? Well, here's why. The panels do end up resolving a number of cases. The percentage is not high, but if you can avoid going to a court case, that is a big benefit. The panel gives claimants a taste of litigation. Claimants also get to hear more than just the biased view of their own attorney. So a patient has a beef with a medical provider, goes, I'm going to call an attorney. The attorney wants to hire them and says, oh yeah, we've handled cases like this. We think you ought to bring it. Pre-litigation panels allow us to give the bad news to that patient that what their lawyer told them about the strength of their case is probably not accurate. So that's a major benefit from the get-go. Panels also allow providers to gather information on claimants and on their own risk at a very early stage, using that subpoena process through DOPL. This tends to make the litigation discovery faster and cheaper than it would have been without the panel process. People go in with a full set of medical records into litigation, and so you get rid of some of those claims that were based on partial information because both sides have the full medical picture of what was going on. You can get a sense of what others think about your position early on. And it manages the expectations of the parties. That patient has heard some things that tell them that maybe this isn't such a good idea to bring this particular case. And they have to go through this panel process within the first 6 months of their being really worked up about things. And maybe they're not so worked up by the time it's time to file in court. Okay, who's on the panel? First, by statute, there is a lawyer on the panel. And that is a lawyer who's completed division training, and that lawyer will represent viewpoints of a judge and will give a kind of a sense of how much of this argument that you're bringing forward, angry patient, really can get into court. Number two is a lay member of the community who's also completed division training. This is someone without legal or medical experience. This person is supposed to represent the viewpoints of a jury to how the members of the community will react to this story that the patient is telling. And third, a licensed healthcare provider of the same specialty as the provider complained of, or the facility administrator for the type of facility at issue. So if they're suing a hospital, it's going to be a hospital administrator. If they're suing a doctor, it's going to be a doctor. If they're suing an LCSW, it's going to be an LCSW on the panel. This person represents the viewpoint of an expert witness and can weigh in on the standard of care. Okay, what happens at a panel hearing? Panel hearings are held in conference rooms in the Heber Wells building on 3rd South in Salt Lake City. It's basically a round table, and it'll have the 5 panelists, the 3 panelists, and then the 2, the medical provider and the patient. And usually there are counsel, there's attorneys for both the patient and for the medical provider. It's very informal. This is not peer review. This is not your chance to show that you're ready for the boards. This is a chance to tell a simple story. Not to data dump, not to show everyone that you're the greatest medical professional and most authoritative person in the room. This is a chance to have digested the medical record and to explain why the treatment provided met the standard of care. What happens is there's a brief introduction, and then the patient, or usually through the patient's attorney, tells their side of the story. This is what we see has happened. When they finish, then the medical professional gets to present. Usually with an attorney going through the medical records very carefully and showing this happened at this time, this happened at this time, here's the standard of care, this complied with the standard of care. There's no cross-examination. Usually the medical professional only answers a few questions from the panelists for clarification. The narratives are given by both sides, by the attorneys, and usually you have very little to say in this particular pre-litigation panel. After both sides have presented, you're excused, and the panel goes into conference for about an hour, and they make a decision on whether they think that there was a breach of the standard of care or there wasn't. Is the claim meritorious or non-meritorious? And they take a vote. And then they call you up and inform you what the panel decided. Ultimately, it doesn't matter. Usually the panel hearing lasts less than 2 hours. All right, let's say you get the good news. The panel found no merit. Are you done? Well, no. The panel decision has no finality about it. Even if the panel finds no merit, claimants can still decide to bring suit. However, this I have often seen. They may have a very fine attorney representing them in the pre-litigation panel hearing, but that attorney may decide, I don't want to represent them in trial. I've heard too much now. They may lose their good attorney and get to someone who's far less effective. If the panel finds the claim is meritorious, that alone is not reason to panic. Sometimes you get a panelist who's a self-proclaimed perfectionist and says, well, I wouldn't have done it that way. That's not the standard of care. They may substitute their own personal standard of care, and that is not the standards that you would face at trial. A court is not going to allow somebody to hold people to the highest standards in the industry. It is to what is the standard in the industry. All right. The pre-litigation panel puts the time to file your complaint on hold. So they have a number of days after the pre-litigation panel has made its decision to actually file their case. Duty to serve on panels. Here's the other way people end up before panels. You can be asked to come in by DOPL and serve on a panel for one of your peers. It's a condition of your healthcare license that you agree to serve as a panelist on pre-litigation panel hearings, kind of like jury duty. You can be excused for unreasonable burden or hardship. Failure to appear can lead to fines of up to $5,000, and repeated or intentional failure to appear is unprofessional conduct and may have ramifications against the license. Any questions?
I have one. So they were talking about in Michelle McConver's report on the legislature that there is some movement to eliminate litigation panels. Why is that happening, and how likely is that to happen?
Well, it didn't happen in the last legislative session. The only changes that they made were to include some updated references. The biggest change recently has been to put in an exception for court-appointed therapists. They found that they were being sued. People were angry with the decisions of the court-appointed therapists and were trying to use DOPL to get revenge on them. I haven't seen a big push for that. I think that the healthcare lobby is in favor of keeping it because it does provide certain protections. And the healthcare lobby has a degree of influence at the legislature. But you're always going to get certain voices that are saying, hey, it's time to change things up. Any others? Unfortunately, no, though federal and state jury duty are tied. And so there are ways that you can use your jury in one to get out of the other. But if you're looking to get out of jury duty, urinary incontinence is usually the top selling point. Any other questions? Sure. That's an interesting question. I tend to like the way it is where it's just informational. The appellate courts tend to be protective of their own domain, meaning the judiciary likes to see the pre-litigation panel be non-binding because they want everybody to have their day in court. It is their constitutional right to have a jury of their peers. So they tend to get protective when things become binding that are outside of the judicial system. The appellate courts have weighed in on pre-lit over the years, and they have when the Healthcare Malpractice Act had certain damages caps for wrongful death, the appellate courts overruled those. They have weighed in on time frames for filing and those things to protect people's access to the courts. If you're looking to do that, though, the best way to do that is an individual agreement with your patient to do binding arbitration. That way you can achieve the same result without having to wait for the legislature to make it binding, and then the courts can't really do much because there's an enforceable agreement between doctor and patient. Well, I hope that everyone feels that, okay, I understand this a little better. I don't need to worry too much about it. If I do find myself facing a pre-litigation panel, I know that I can just talk to my malpractice carrier and they'll take care of me. If you happen to be in an area that does not regularly have malpractice coverage, birthing centers, midwives, may I suggest look to get that coverage because it can be a real lifesaver in a situation where you're facing pre-litigation panels. Thanks.